May I proceed? Item number 43, my lord. We have filed the affidavit in reply today morning itself, my lord. So matter may come, my lord, either next week or after due vacation.
43.
Reply, my lord, we have filed against the affidavit of the government, my lord.
Object.
May it please the Lordship. Lordship, I'd like to mention item number 38 for adjournment. Lordship, we'd like to file an additional affidavit in the matter.
Madam, what remains in this
Uh,
matter? On the
Lordship-
last occasion, we asked you to complete your instructions. There is nothing in this matter.
Lordship,
We have already placed you the order for 2024. Now what-
exactly, Lordship, the order of 2024 has been modified, and it has been modified in a manner that it amounts to it being cancelled. This is what the instruction is, Lordship. That is,
Cancelled?
Lordship, that is the instruction that I have received.
Nothing in the matter.
Lordship, kindly grant me 1 day's time. I'll confer with
Just
the.
after 8 weeks, at the request of land council for the petition.
May I please, your Lordship? My lord, I beg to mention item number 44, Lordship.
44.
Lordship, matter has already been admitted and question of law has already been formulated. So let it come up for final hearing.
Check it. It's already there. Okay, we'll wait for your turn. We'll
Lordship.
look into it then.
Lordship.
May I please, your Lordship? Lordship, I beg to mention item number 46, my lord. We are not, we want to withdraw, my lord. We want to withdraw, my lord.
Want to?
Withdraw, my lord.
Why you are not provided the details?
My lord,
You want to withdraw?
yes, my lord. My lord, petitioner did not communicate with our chamber, my lord.
Petitioner is, I understand the petitioner is a very busybody and nothing else. And you ask you to furnish the information regarding the tenants, now you wants to withdraw, okay, wants to withdraw, dismiss this, withdraw. Simple. Dismiss the withdraw. No liberty.
What is your name?
R.I. Bhuya, my lord.
May I please, Lord? Lord, I have a prayer for listing of the retail, Lord. We have filed the retail on Saturday, Lord. I kindly permit us to move the appeal on Wednesday, Lord, day after tomorrow. Some urgency is there, Lord.
May please, Lucy, I pay for listing of a rate appeal, being rate appeal number 41 of 2023, Lordship. On 3rd or 5th of this week, Lordship, there's some urgency, Lordship, in regard to the matter. If possible, Lordship,
What's the urgency?
urgency is the Lordship, the matter was last listed for orders, Lordship, and it was shown that in the office note that the
Thursday.
notice was not with.
Thursday.
Possible, Lordship.
Daily list for orders, item 1 to 3.
Lord, on behalf of the respondent number 2, we have filed a detailed affidavit, Lord, pursuant to Lordship class order.
On which matter?
Lord, in item number PIL 50 of 2016, item 1, Lord.
So what measures you have taken now?
Lord, we have indicated, Lord. Lord, kindly come to para 4, Lord.
Para number?
Para number 4 at page 258, Lord.
258.
250. It's a running page, Lord. Other internal page is page number 3.
Yes.
No, you filed an affidavit on 18th of March 2024.
18th of March.
That starts from 275.
But possibly there is some mistake.
Yes,
I stand corrected, my lord.
it is by Sampriti,
Yes, my lord.
Sampriti Goswami.
Some pretty good one, my lord.
Yes, para
Correct.
number 4.
Para 4, my lord, we have indicated these steps, my lord.
And one for municipal board and one corporation.
The existing waste processing capability of urban local bodies, we have indicated. And the organic waste converter, kindly see the next page to Roman para 4, to Roman 4 point is there, my lord. Present scenario of solid waste management in ULBs of Assam. Total waste generation is 1311 TPD tons per day, my lord. Plastic waste generated is 272 TPD and the CND waste generated 96.1010 TPD. The collected amount we have said and the existing waste processing capability of ULBs we have indicated here, Lord. And
Mr. Das, it seems it is only on papers.
no, my lord, the work,
Otherwise also go through this city and you will find garbage is everywhere and no proper system is there, not at all.
the works
Can't
completed,
even
work,
believe
some,
this, whatever you have mentioned.
Okay.
All on paper and nothing else.
but some works are under process, my lord. That's I do admit, my lord, they are working.
What is the purpose of doing all this exercise in paper?
No, my lord, we are not sitting idle, my lord. We are working, my lord. We are working kindly.
Who is
It will take some time, my lord. I do admit, my lord.
For item number 1, madam.
Yes,
As far as my case is concerned, madam, our grievances have been addressed.
your,
My case is concerned, madam, our grievances with regarding Dibrugarh, it has been addressed, madam. We have filed the PR regarding the shifting of the dumping area. My place already been shifted. However, the lordship wanted that all the matters should be taken together and find proper solution. So we are here, madam.
In item number 3, Lordship, regarding Nagaur district Lordship, they are supposed to file affidavit regarding solid waste management plan Lordship. But till that no affidavit has been filed Lordship.
what about this municipal area in the Shiv Sagar town? Who is appearing amicus in this matter? Item number 2 PIL.
Mr. Das, could you please come forward? Mr. Das, these 3 cases, although the original grievance has been redressed, but the court has kept these matters alive to monitor the overall situation in the state about cleanliness, solid waste management, etc. Would you be open to assisting the court as an amicus in these matters, if appointed?
In fact, a similar matter also I am
That's-
doing in
that's
the
the reason.
before bill matter. Lordship.
Yes, because we published.
These 3 PIL petitions are being filed in individual capacity with a prayer to direct the respondents to address the problem of garbage and to
Waste management. Shifting of dumping ground and waste.
and the shifting of dumping stations in the city of, in various cities, as well as regarding the solid waste management in the state of Assam. So, all these petitions are heard together, taking into consideration the fact that the solid waste management in the state of Assam is a is a problem which is faced by the residents of state of Assam since long. Stop. Response has been filed on behalf of the state, wherein it is indicated that certain measures have been taken by the state to address the problem of solid waste management in the state of Assam. Stop. Having considered the facts and circumstances of the case, we deem it appropriate to request Mr.
DK Das.
DK Das, Mr. DK Das advocate, to assist the court as a amicus curiae. Stop. Mr. Das has accepted, but is ready to be ready to assist the court as amicus curiae in these matters. Stop. With these matters, after showing name of Mr. DK Das as counsel, as amicus curiae, all the records, such as the writ petition as well as the responses filed on behalf of the various respondents be furnished to Mr. Das within a period of 1 week. Mr. Das may submit his response within further 2 weeks. Within further 2 weeks, based on so and so 3 weeks के बाद की date.
Right.
Item 4,
May I please? In pursuance to the order dated 23 February, we have filed our affidavit regarding paper publication.
You already filed the compliance report.
Yes, Lordship, that is on record. I have checked.
Affidavit is filed on behalf of the
Applicant.
appellants along with the IA is filed on behalf of the appellants indicating the paper publication of notices upon the respondents numbers 42, 47, 57, 71, 73, 79 and 94. Top copy of the paper notice is also attached along with the IA, taking into consideration the same, we deem it appropriate to treat the service upon the respondents number so and so as complete. Is this matter after you are appearing for?
And for some of the respondent lordship, except my lord, recently they have taken step, my lord. Others we are appearing lordship.
You are not appearing for on behalf of all those other respondents?
No.
They have indicated.
No lordship.
And she presents, Marcus presents for the respondent, you please give it
Yes,
in
I
writing.
will take lordship.
This for admission after 2 weeks.
My lord, may I pay for copy of the retail motion?
Yes, I.
item 5,
Chief, I want this time to take a step, Lordship, because there was some, due to some misunderstanding, it was
Mr. Consultant, so pays for a granted a week's time to comply with the order passed by this court on 23/2024. And compliance, on making the complaints, that notice be issued to the sole respondents to registered post AD returnable on front. So
Item 6,
Six, my lords, we had on the last date, my lord, they have some instructions, my lord. Inadvertently, we missed those. I like kindly please, my lord. The grievance, my lord, regards the operation of JCBs, my lord, the route of the Mohol has been changed. And also, my lords, the no settlement is given. Only government permits are allowed. And my lord, the number of vehicles which were operating, my lord, the numbers are also made public.
File an affidavit.
Yes, ma'am. We'll bring that on
File an
record.
affidavit. Those, these specs on record.
My lords, definitely.
Last time also you, took some time to file counter affidavit. to the-
Yes, my lord, last time, my lord, had it been produced last date, my lord, by now it had been come by affidavit. We missed out that.
We go away, then concept appearing for the respondent forest department takes a week's more time to file counter to the IA number 2341.
Right.
Just after a week.
Obviously.
Highly obliged.
item 7,
See, it's complied with. Lordship.
Your complaint.
Yes, your lordship, the SLP was dismissed and they have issued the appointment order on last Friday, that is on 29th, and he has joined today.
He has joined. Here, then the concept of the petitioner has submitted that. The respondents have already issued appointment order and pursuant to that, the petitioner has also joined. Appointment order on 30th of March 2024.
Into Aziz.
So you are joined on 30th itself,
No, sorry, today he has joined you.
and pursuant to that, the petitioner has joined on the post of principal Girls College. Sim Sagar Girls College, Siv Sagar. On, Siv Sagar today itself. To stop, in view of the fact that the appointment order has already been issued in favor of the petitioner. Are of the view that we are of the view that substantial compliance of the order passed by this court has already been done, and no further order is required to be passed in this petition. The contempt petition is disposed of, notice is discharged.
Much obliged.
item 8,
May kindly peruse the order dated 5/2/2024, Your Lordship.
Yes,
May it please your lordship. Lordship, we have received instructions, lordship. We would like to file it in the form of an affidavit, lordship.
when?
Lordship, within 2 weeks, lordship. And then, lordship, within 2 weeks, lordship,
2 weeks?
or it's one.
Seems you are already in this for 2 days.
And lordship, in this whole state of Assam is divided into 5 zones, lordship.
Whatever it may be, file your response at the earliest.
Yes, lordship.
Okay. Yes, Arborua, the council appearing for Mr. D. Sekia, Advocate General Assam. Is granted a week's more time to file an additional affidavit bringing on record the status report with regard to the functioning of the mental health review board. List after a week.
Lordship. Oblige, your lordship.
Item 9.
May I please the lordship. Earlier order dated 15/11/2020, kindly see lordship. And 6 and 7 yet to be received the acknowledgement of lordship.
Respondent number 6 and 7 has already been served.
Yes, lordship.
Who is appearing for respondent number 6 and 7 and who is appearing for the state? Yes, Mr. Chaudhary.
Nine.
Mr. S.S. Roy, Central Government Council. Who are the respondent number 6 and 7?
Six and 7 lordship, State Bank of India Centralized Pension Processing Center lordship.
Why they are necessary party in this?
Lordship.
Why this 6 and 7 are party?
Is a family pension lordship.
Family pension.
Yes,
Okay,
lord.
unless they'll pass the order, the other respondent will pass any order. How the bank will disperse the pension?
Lordship, area pension is pending before the bank lordship.
Mr. S.S. Roy.
My lord, kindly accommodate today, lordship. I will inform him, lordship. I will inform.
For the time being.
Lordship, for the
All
time,
right.
for the time, lord, oblige, your lordship.
Item 10.
But in this matter, my lord, I'm appearing for respondent 3, 4, and 5,
You are appearing for, yes.
my lord, and we have filed our affidavit, my lord.
What about respondent number 7? Who is the respondent number 7?
7 is UGC law, University Cost Commission.
University.
The primary grievance is regarding appointment and selection in our university.
Yeah, file your response.
We file our response, madam. We
Your
have already
Lordship,
filed our
we need
response.
2 weeks of time to file the affidavit for reply.
Madam, we have doubt regarding maintainability of.
Exactly, madam.
pension even.
Exactly.
How it is maintainable? Is there any financial irregularities or something else? File a criminal case. How this PIL? It would be very difficult for the courts, even for every institution, if such type of petitions are filed.
It's a smear campaign, my lord. It's a smear, it's a frivolous petition, man. Absolutely frivolous.
There is any, if the university personnel has committed any illegality or any crime, file a financial irregularities, use loss of public money, file a criminal case for that. This is a cognizable offense.
Your Lordship, I have to discuss with my senior. My senior is lagging another court. So
By University Grants Commission, what relief you have sought against the University Grants Commission?
Nothing, my lord. Look at the prayer, my lord. They're seeking a judicial inquiry or an inquiry by a high-powered empowered committee by the government.
Why this
That is it.
criminal background and also appointing post quota missile of? Who is the petitioner?
My lord, he was a retired professor of a college.
In this university?
Not, my lord. This is a Hojai college, my lord. Hojai college was subsequently upgraded to this university.
Belong to this university only?
No, he retired before upgradation. He retired before upgradation.
Somehow connected with the university itself.
My lord, he was acting as a proxy of some, my lord, association, teachers association. I will show it from the documents, my lord.
And there is no.
Where is your senior, madam? Where is your senior?
In court 7.
Call him. We are passing it over for the time.
Item 11.
Look, here, Malad, kindly give us 10 days time. Like, we have taken drastic steps, but this step, it has not come back. We have to take it again.
And concept of the appellant place for him, 10 days time to do the needful. Stop the 10 days.
Item 12.
Wait, please. Where are we?
When the matter was decided by the Honorable Supreme Court.
My lord, that was on, my lord, 20th of July 2023, my lord.
Prior to that, there was any stay.
No, earlier there was no stay, my lord.
Then the order is of 2015 and now you have filed this.
No, my submission before your lordship is that while passing the order dated 7/10/2023, Annexure 6, page 31, the Director of Higher Education has done contempt of court, my lord. Page 31 is the order, my lord. And relevant will be page 33. My lord, the division bench held that governing body had no jurisdiction to take disciplinary action against me, it being a government college. Therefore, a de novo inquiry was directed to be completed within 6 months. Because it was I had already retired long back, my lord. Now it went to Supreme Court. Supreme Court also upheld this, my lord, said that you have already initiated some inquiry, complete it. Now director is passing the order saying that in a way the division bench was not correct, governing body rightly did it, my lord.
Where is that?
My lord, that 33, my lord.
Yes.
Accordingly, the inquiry officer has submitted necessary inquiry report dated so and so, whereas as per Rule 62 of the Assam Service Pension Rule, resignation from public service or dismissal or removal from it from misconduct, insolvency, inefficiency, not due to age or failure to pass a prescribed resignation entails forfeiture of his past service. Hence, as there is no scope for reinstating the incumbent as per Honorable High Court order, it is so and so dismissal order has already been passed by the governing body's resolution number so and so, as governing body is authorized to determine the discipline and conduct of the teaching and non-teaching staff of the college as per Rule 21 of the Assam Non-Government College Management Rule 2021, as the period of dismissal and suspension falls under the transit period between Assam College Employees Provisional Act so and so and rules framed thereunder in 2010. After careful examination of the inquiry report and the record, documents submitted including the show-cause reply by the petitioner, Sri so I am of the considered opinion that Sri so was dismissed from service in accordance with the provisions of law.
Where is the division bench order?
Division bench order is lordship. Now, page 16 it starts, my lord. Relevant would be 19, my lord. Paragraph 12 and 15. After discussing all the provisions of law, my lord, there are 3 acts and rules, my lord. In that view of the matter, we hold that the governing body had no right to hold inquiry into the matter and pass order of dismissal later on sent to director for approval. And then 15 also it says, my lord. DB basically said that it being a government college, where director is the appointing authority, the governing body did not have power to hold disciplinary proceeding, nor to pass dismissal order. So de novo inquiry within 6 months in 2015, you have passed, my lord. Now, after 7 and 8 years, my lord, director is passing this order, my lord, saying that GB was correct. In my humble submission, my lord.
This order has not been challenged. Let's go to the 7th October. 20th July 2010. Also include
Issue notice. Returnable on so and so. Wasted date, wasted date. Yes.
Item 13.
Under challenge in this present reticle, my lord.
The clause
By that clause, my lord, there is a requirement of having 3 years of minimum service for deceased, my lord.
issue notice of the IE number so and so, returnable on so and so.
Item 14.
14 is also same, my lord.
Same.
Oblige, lordship.
Item 15 to 29.
This application was filed under an early date of hearing. Our fear is that the judgment was a very recent judgment which went in our favor. The lordship on the 27th of February had fixed it in the month of August. So if it would be in the month of My lord, May 15 by 15.
You already fixed the date in.
My lord, only our anxiety is that, my lord, because this issue has to be decided, my lord, there's an injunction also. And the government is also ready with the hearing.
A month before we have fixed the date in August.
Yeah, that is the, well, that day, in fact, I could not make a prayer. I was in the midst of a hearing, madam. So can it be as agreed upon in the month of May?
I leave it to this honorable court's convenience. We are ready for any vote.
Maybe. Comes upon for consideration of the application. IA number so and so referred on behalf of the respondent, then where to this to fix a date of to fix a date for hearing in the connected appeals in the month of May or June 2024.
If it is in the last week of May, Lordship, if otherwise last week of July,
4th of June.
4th of June.
Malad,
4th of
can
June will be difficult, Lordship.
Can it be on the 13th of June?
Lordship, in June, I am mostly out of the country, Lordship.
Malad, I'll be also
Maybe in
out of.
June or in July, Lordship.
Malad, July will be later.
को भी साथ ही ले जाएं।
Malad, I'm also.
ये नहीं जाएगा, Lordship.
No, I'm going. I'll be out of the country, Malad.
You will also
Yes.
also the country.
We have very good VC facilities. now.
Last week,
We have very good VC facilities. We have not tested it.
In the vacation, Malad.
I have done it a lot of times, Lordship. It is really very effective. One of the best in the country, Lordship. Our High Court.
We'll fix it in August.
But August will be, can it be in July?
Immediately after reopening in the summer vacation.
August. we already fixed.
Lordship. Highly applied.
This IA number so and so is held on behalf of the respondents with the prayer for early listing of the connected appeals for hearing. Which committed notice that. It is noticed that on 27/2/2024, this court has fixed fixed the matters for fixed the connected appeals for hearing in month of August 2024. Hence, the IA is disposed of. List the connected appeals in the month of August 2024.
Can it be on the 1st of August?
2024.
Highly applied.
The date already fixed. 7/8/2024.
इसमें the date has been mentioned as 7/8/2023. So check it. इसका जो ऑर्डर है
On 7th of August, only simple detail.
For admission, item 30.
Wait, please, Your Lordships. Your Lordship, I'm praying for a short accommodation in the matter.
The case of non-counsel of 4 weeks.
Mashallah, Your Lordship.
Item 31.
Look, here service is completed. My friend, he is appearing for the respondent number 1.
Similar matters are.
Similar, yes, fellow, similar matters are admitted.
They have already been admitted.
Yes, Lordship, other similar matters are there.
Lordship.
Yeah. Having heard the non-counsel for the parties, we deem it appropriate to admit this petition, hence admit, no need to issue notices. Parties are already represented. This for hearing along with number they unka.
Retable number 50 of 24.
50
of 2024.
May I pray for a date of hearing, Lordship, because the.
Yeah.
Pray for a date for hearing, Lordship.
That has already been fixed in that connected matter.
My Lord.
Item 32.
But in 32, service is not completed. Lordship may give us. Already we have filed the affidavit, my lord. We have served the copy on the respondent number 1.
You already served the copy for.
We have served, my lord.
Other party.
Yes, my lord. The respondent number 1 has received. We have filed we have taken dusty service and taken staff.
Who is appearing?
Nobody appears.
You served the copy to whom?
To Kamal Dehinga, the respondent number 1.
The respondent number.
Yes.
The copy of the appeal has already been served upon the respondent number one. However, no one is appearing on behalf of
But,
him.
sorry, but delay has already been condoned. It has come for after that it has come. Lordship may admit the appeal.
That's what we are doing.
Lordship.
Copy of the writ appeal has already been served upon the respondent number one. However, no one is appearing on behalf of the respondent number one. Admit. Issue notice to the respondent number one. Returnable on so and so registered AD.
Lordship.
Item 33.
I am for the respondent number one writ petitioner.
For the other side.
I think Mr. K. N. Chaudhary appeared.
For the day. Pass over for the time being.
Well, let it be some other day, my lord, instead of time being.
Yes.
Your lordship, pass over for the time being, your lordship, senior counsel is on his way.
Seeking some, Mr. Chaudhary is seeking some time.
No, if
Okay, we'll pass it over, then you make a request for the time being.
Highly obliged, your lordship.
Item 34.
May I please, your lordship, I have instruction to withdraw the matter, lordship. There's some defect in the petition, so we can file it on hearing.
File a fresh one.
Lordship.
What's the,
Wrong is that, my lord, we have invoked the Article 226 as well as 227. So that is the part.
you got an assurance from the DRT,
Pardon.
but how this petition is maintainable?
We have prepared the special measure there. On
Special?
special circumstances there.
Special circumstances, what special circumstances?
Is that, my lord, the-
Reviewed by the order of the DRT, file appeal before the tribunal.
Yes,
Under section
I,
18.
yes, but there is some provision that this honorable court may interfere the matter when there is some defect in this in the processor and the petitioner is not being done.
The tribunal, point it out to the tribunal.
Yes. So in by this time, we will let it be. We will be doing. We will file petition there. Obliged.
Wants to withdraw.
Yes.
With liberty to avail appropriate remedy available to the petitioner in law.
Item 35.
Just Somoto PIL, my lord. That, my lord, Borsala bill, there is a natural water body, my lord. And that, my lord, there is a direction to preserve and protect that, my lord. That is only in papers only, my lord.
Should notice.
My lord.
Returnable. So and so, 3 weeks ka date.
Deeply observed.
Registered AD.
Item 36.
Please, your lordship, my lord, this matter relates to illegal construction undertaken by the government runs.
School, government
Yes,
school
ma'am.
building, how construction can be termed as a.
Your
illegal?
lordship may kindly see, we have, there's a complaint from our side, my lord.
What?
After
what is the
receiving the complaint, your lordship may,
Annexure B. is your complaint?
annexure, to page 21, your lordship may kindly peruse. Annexure C, my lord. After receiving a complaint, my lord, this notice was issued to the my lord, the respondent school, my lord. But in spite of there is no permission and they have been continuing the construction.
What is your objection if a construction is going on in a?
My lord, I am the neighbor and the
No, how
person
you are
of the
aggrieved by that?
locality. Your lordship may kindly see, I have given certain
Whether they are
photographs.
raising
My
any construction on your land?
my lord, attached, my lord, the neighbor, my lord.
Where is the?
That is why I have,
permission? In a school building, government school building, if some construction is going on, how you are agreeing?
your lordship may kindly see the photographs. It is attached to the wall of the drain, public drain. It is a public drain, my lord.
Public?
Municipal. my lord. It is attached to the public, my lord, my drain. Your lordship may
Where is the
kindly.
drain? Where is the
Yes.
drain in this?
Your lordship, annexure A series, your lordship may kindly see. at page 14, my lord. And because of the construction, your lordship may kindly see the blockade of the whole drain, my lord. Page 15, my lord.
Yes, page 14.
Yeah, page 14, your lordship may kindly see the wall. This is the wall of the public drain.
This is the.
And wall of the public drain, my lord. Public drain, my lord.
Even
And the next page, your lordship may kindly see it is because of this construction that there's a blockade of the drain, my whole drain, my lord.
After
And the whole
after the construction is over, then.
No, my lord, it is covered, my lord. The cantilevers has covered the drain, my lord.
We are not.
So, my lord, the public has been
building, some
suffering.
construction is going.
And there was
they are
house man.
raising in their building, how you are concerned?
My lord, your lordship may kindly see, they have not followed the, my lord, provision of the zonal, my lord,
Who
regulation.
appropriate representation before the municipal authorities.
Yes, my lord, that is why complaint has been lodged, my lord. Your
Yes.
lordship may kindly see annexure B, my lord,
Annexure
at page
B.
19, my lord, B1, my lord.
Yes.
After receiving this complaint, action was taken, my lord, a notice was issued, but in spite of that, they are continuing the construction.
So they must be having their.
Page 19, my lord.
Yes, they must be having this NOC permission, etc. Everything.
No, my lord, nothing, my lord.
That's why only they are continuing.
That is why we have filed writ petition. And so that as per the direction of the honorable court, we have to withdraw. The last page.
Annexure D, read your representation.
Yes, ma'am.
Was a grievance actually. With reference
May I
to
read, my lord?
your information, it is that Authority of Government Girls Higher Secondary School is situated Club Road, Silchar, has initiated construction of a building without obtaining any and also without maintaining the requisite setback for construction of boundary and government sector, which is in clear or zoning regulation norms framed time to time. It is pertinent to mention here that on the backside of the said school, there are municipal drain where whole drainage water is passing by, and the authority initiated the construction of the building over the municipal boundary wall, which is in violation. There are so many innocent students studying in this school. If the building is constructed near the municipal drain, there are so many students will suffer from various germs, which is very unhygienic, and moreover, there's various illness. It's a vague allegation. How?
On the basis of this
Therefore, the
allegation,
building required to be demolished as early as possible.
then
Without commenting on the merits. Okay. This petition is filed by the petitioner. The design of public interest. Essentially being agreed with the construction activities. Being agreed with the ongoing construction activities in the premises of Girls Higher Secondary School, Silchar. Stop. From the representations filed by the petitioner before the Executive Officer, Silchar Municipal Board, and the District Commissioner, Kachar, Silchar, it appears that the petitioner is claiming that the said construction is being raised by the school authorities without obtaining necessary permissions from the local body. Full stop. Having heard the learned counsel for the petitioner and after going through the contents of the petition, we deem it appropriate to dispose of this writ petition with the direction to the executive officer, Silchar Municipal Board, Kachar, to consider and decide the representation filed by the petitioner if the same has not been decided till date, strictly in accordance with law, expeditious.
Public.
Item 27.
After providing opportunity of hearing to the concerned parties.
May it please your lordships. Appellant before your lordship, my lord, is aggrieved by the my lord order dated 29/11/2023, my lord, passed in WPC number 4431 of 2021, my lord, in the single bench, my lord. Kindly come to the order, my lord. Here, my lord, the fact of the case is that, my lord, the petitioner's father, my lord, was a my lord, junior engineer, my lord, who died in harness on 13/1/2015, my lord. Therefore, my lord, petitioner being graduate, my lord, having educational qualification, my lord, he had submitted an application for appointment on compassionate ground, my lord, on 5/2/2015, my lord, before the executive engineer, PWD Rural Road Division, Goalpara, my lord. And accordingly, my lord, the district level committee had recommended his name, my lord, against the post of junior assistant, my lord. Now, what happened, my lord, although the district level committee has recommended his name, my lord, against the post of junior assistant, my lord, against a particular single vacancy, my lord. Anyway, my lord, but his case was not placed before the SLC, my lord, state level committee, my lord. Subsequently, the petitioner had approached before this honorable court earlier, my lord. This honorable court had directed them to replace the case of the petitioner.
There,
SLC,
considered
my
your
lord.
candidature and found that 5% vacancies are not available, and for the
And,
other post, you are not having the requisite qualification.
My lord.
Yes.
Now, my lord, what happened, my lord? Actually, my name was recommended against the post of junior assistant,
Yes.
against which I possess the qualification, educational qualification, my lord. Now, subsequently, what happened, my lord? They have placed the case of the petitioner, my lord, considered the case and rejected, my lord, against the post of section assistant, my lord. I was not recommended, my name was not recommended by the section.
Petitioner has been considered for the post of junior assistant on other than there was no vacancies in the post of junior assistant
Well,
with 5% quota reserved. For the compassionate appointment, the petitioner was considered against the senior section assistant. However, the petitioner could not be recommended for the post of section assistant as did not have the required eligibility criteria of higher secondary science. That's all.
My lord. Yes, my lord. Now, they have stated this fact, brought this to the notice of the court, my lord, by the affidavit, my lord. And that was also reflected in the impugned order, my lord. That order, my lord, page 68, my lord, paragraph 8, my lord. Rule 8 of the All Assam section assistant and subordinate engineer PWD Road Wings Service Rule 2018 states that the academic qualification of the candidate for the direct equipment for the post of section assistant shall be SSLC passed from any recognized board in science stream, my lord. My lord, kindly, my lord, this act, my lord, these rules has been enacted in the 2018, my lord. And my lord, my case was, my lord, I had applied for against post of competition ground, my lord, in the 2015, my lord.
Which are in vogue, they will be considered for that.
Now, my lord, against a post, my lord, against who is, my lord, if I am not educational qualification, my lord, they can recommend it to any other post, my lord.
Oh, he's not saying that the findings are correct. So rules में लिखा है ये हो सकता है लेकिन आगे चल के साइंस
मेरे केस 2015
My lord, this honorable court, single machine, the various orders, my lord, has rejected, is another other case, my lord, had rejected to consider some such cases, my lord, to accommodate against the post commensurate to their educational qualification, my lord.
That can't be done. That can't be done.
That whatever, my lord, that is separate aspect, but in the instant case, my lord, this rule of 2018 has been enacted, my lord. Whereas my post was, my lord, I had applied 2015, my lord.
Whatever it may
At
be
the
now,
time of, kindly,
now at present, what are you doing?
my lord, may I refer to one, my lord, decision of the apex court, my lord, in the Delhi Jal Board versus Nirmala Devi case, my lord. in this case, my lord, the honorable appeals court had held that at the time of the submit filing application, my lord, the educational qualification is to be counted, my lord.
So at that time, what was the education qualification for the post of assistant section officer?
My lord, at the place of, at the time of, my lord, I don't know, my lord, because this rule
Don't
came
know
with
then how you are
2008.
claiming?
Well, this rule has came to effect in the 2018, my lord.
Prior to that, what was the requirement for the appointment on that post?
And they will be in better position, my lord, because this
They
says
will
that
be in better-
2018
You
rule,
have
my
to
lord.
prove your case, Mr. You have to prove your case.
My lord, I had submitted an RT application also, my lord. The pertaining to the what actually
Earlier,
the
which rules were in vogue prior to 2018? Which rules are in force? Were in force?
my lord. To 2018, my lord. Why I am submitting, my lord.
Rules were in
If
force?
that post was section assistant, my lord. In fact, my lord, I have also noticed, my lord, some candidates were appointed, my lord, without science qualification, my lord.
That the learned
section
single judge has
assistant.
already said, if the rule says that the science qualification
That
is
is why, my lord,
required, and if any other, persons were appointed ignoring that, we can't give that relief against the law.
my lord. My lord,
Yes.
now, my lord, the applicant has submitted the RT application, my lord, seeking the information actually as to the what was the qualification, my lord, prior to 2018, my lord, for the section assistant. Well, that information has not even given, my lord.
That RTI application, what the RTI application will do?
My lord,
Which were those rules in vogue in 2015?
my lord, actually they are appointing, my lord, several, we are also confused, my lord. Actually, so what is the actual qualification prior to 2018, my lord? Because, my lord, ACS pass candidate also appointed against section position post, my lord.
Mr. Consul, if you are seeking appointment on the post of assistant section, you have to satisfy that you were having that position in the year you are having the required qualification in the year 2015, and what was the required qualification? You have to show us.
My lord. May pray for some time, my lord.
The concept for the please for some time to apprise this court about the apprise this court that in the year 2000 the requisite qualification for appointment of the post of assistant section officer,
Section assistant.
section assistant is not higher secondary science. Would stop. List after 2 weeks.
Well.
Item 39.
My lord, in this matter, my lord, the CGC is appearing, my lord, another CGC is appearing, my lord. I'm praying for some time. She's on legs in different.
How much time?
A week's time, my lord. Obligation.
Passover meter 9.
I am appearing for Mr. Assessor, not CGC, my lord. He is coming, my lord.
Applying for UGC.
No, my lord, Mr. Assessor, my lord. I am appearing on behalf of Assessor, my lord.
I'm sorry, my lord. My lord, in this case, lordship, no extra copies were served to us, lordship.
What do you mean by extra copies?
For the
One copy you served?
lordship.
One copy was served?
Yes, lordship, I am unable to obtain the instructions, lordship.
You have the railways?
Yes, your
You have
lordship.
for the railways?
Yes, your lordship.
So what do you mean by extra copies? The copy of the petition was served upon you?
Lordship, initially it was one copy is served.
So, Mr. Gogoi, your client is a second wife, right?
Yes, Lordship.
When was the wedding with the second wife? When did it take place? During the subsistence of the first wedding?
Yes, Lordship.
Huh?
Yes, Lord.
Then it is illegal. You can't claim yourself the status of second wife.
Already first wife had died, Lordship.
Hmm?
Already
When?
first,
When?
2021, Lordship.
But you solemnize second marriage
Lordship.
when she was alive.
Yes, Lordship.
So how this marriage is recognized?
Lordship, as per law, it is not recognized.
Then
But Madras High
per law it is not recognized, but since.
subsisting marriage is legally not a
Yes, so
wife,
it is
Lordship.
therefore it is recognized.
As per various judgment also pass, and Madras High Court also pass a judgment, Lordship, kindly see, I have given you, Lordship. It is cohabitation is continuously husband, that is also recognized the second wife as a wife, Lordship.
Why haven't you given him extra copies?
I'll give, already I have advocate club given the extra copy, but he did not give him, Lordship. I'll give him, Lordship, today itself.
Nikhil and concept for the the petitioner. Then concept for the petitioner pays for and granted time to furnish the extra copies to the concept for the respondent number 1 to 5. On furnishing the same, then concept for the respondent number 1 to 5 may file his response. Within a period of 1 week, furnishing within a period may file his response within a period of 2 weeks, thereafter list after 3 weeks.
Lordship. Highly obliged.
Master Barometer 10.
Yeah, my lord, before lots of tax, my lord, and before the case go to scaffold, my lord, I've got some physical problem today. Can it be taken Friday or Monday, my lord? Let me argue also.
Let it be on Friday, man.
Friday.
Otherwise,
I know,
he
my
had
lord,
not
yeah.
inclined he had not inclined to entertain this petition simply because if there are some irregularity
Lord, I know
or
it will-
misappropriation of
Yes,
fund
yes,
or whatever it may be. on
Yes,
file
my
a
lord, I
criminal
know,
case.
it will face the news, my lord. Hanging news it will face. But before that, let me submit also, my lord.
After a week.
After a week. Obliged.
Master Barometer 33.
Made vigilance.
My lord, the issue that falls for consideration in my humble submission is, my lord, if the appointment is illegal, my lord, whether a disciplinary proceeding is a necessity, no. And that is the view seems to be of the learned single judgment.
And why you have served him a notice?
No, my lord, no, I'll satisfy your lordship. It's true, my lord. We have served him a notice. He did not respond for, my lord, there's almost more than 2 weeks. Thereafter, we passed the order.
No, in fact, he wrote an application on a particular date. And
No.
Short time for 2 weeks and. on
No,
the
my
next
lord.
day you have passed the
This
order.
show cause notice is dated 3rd of April 2023.
Yeah.
And my lord, we passed the impugn order on 19/4/23.
No, prior to that,
Prior to that, he came up with a letter on a mail on 18/4/23.
yes.
No, my lord, no, my lord, my humble submission would be, if any prejudice has been caused to the writ petitioner respondent, he can satisfy lordships here also that this is the prejudice which has been caused to him. But he is not doing that. He's only saying my right has been violated. But let him show, my lord, how he is an outstanding person, ability that he should be appointed. Let him show. My lord will kindly, this is a case, he is not from the academic side. He was an officer in the railway, NF railway, my lord.
Yeah.
PRO, public relation officer. And we all know, my lord, what is the job profile of a PRO and what is the otherwise required of a professor who is supposed to teach mass communication. And my lord, and the criteria which is required to be fixed as per the UGC norms, those were also not fixed by the university. My lord will kindly come to, first, if your lordships would kindly come to
82.
the notification from the I'll place that regulation of Katajutaniana. Now, please come to my lord, page 60 of that book, that compilation. Roman 3, professor towards the bottom. Eligibility. An eminent scholar having a PhD degree in the concerned allied relevant discipline, published work of high quality, actively engaged in research with evidence of published work, with minimum of 10 research publication in peer review or UGC listed journal, and a total resource score of 120 as per the criteria given in so and so. This is in respect of those who come from the academic side. Then my lord will kindly come, skip over to the next page, B. An outstanding professional having a PhD degree in the relevant allied applied discipline from any academic institution not included in A above, / industry, who has made significant contribution to the knowledge in the concerned allied relevant discipline, supported by documentary evidence, provided he has 10 years of experience. So he falls under this category. He is not an academician. He was an officer in the railway. So what is required to have, my lord? He is required to have significant contribution towards the knowledge in the so-and-so, and it should be supported by documentary evidence. My lord, the two persons were entrusted with the duty of scrutinizing his credentials, my lord, who have debarred him from life from participating because of the illegalities committed in the selection process. Now, my lord, one more very important aspect is, please come to page 76 of this compilation. I'll have a lordship's kind attention to Roman 5.
Yes.
In the case of selection of faculty members who are from outside the academic field and are considered under clause 4.1b, 3b, etc. of this regulation, the university statutory body must lay down clear and transparent criteria and procedure so that only outstanding professionals who can contribute substantially to the university knowledge system are selected. Now, it is an admitted position, my lord. These criteria were not, my lord, framed.
Yes.
Who has admitted?
And my lord, based on some subject of No, no, I'm going to the small inquiry report.
Regulation. Eligibility.
So, Mr. Chaudhary, your case is that the initial appointment of this professor or the respondent as a professor was void ab initio or not in accordance with law. Then show us any law on this point.
Yes, my lord.
Just a,
Yes.
show us that even after services are confirmed.
Not
his
confirmed.
his probation period. was
Confirm,
over,
yes, over.
his services were confirmed. Then for the purpose of removal, he is not liable to be subject to the regulations.
Oral hearing.
Or the regulations are not required to be complied with or
Yes.
followed or whatever it is.
My lord, let me articulate my argument, my lord. There
He-
are two ways we can
if
look at
he-
it. my lord.
If the situation would have different, if the respondent was in the probation period, certainly you can very well say that for this, we can remove.
No,
it.
my lord, when it comes.
But once he is confirmed employee,
Hmm.
then certainly whatever it may be the learned single judge, prima facie we are of the view as rightly held that
Yes.
before adverting to the procedure laid down under the regulations, you can't terminate a.
My lord, we referred to several judgments which are noted by the learned single judge. Please come to page 137.
Yes.
Page 137. Para 21.
Yeah.
Sri so-and-so in support of his submission has placed reliance on the following judgment. My lord, I'll refer to serial number 4, 5, 6, 7, and 10. And 10 is a judgment of division bench of our High Court where it says in such a situation is not required. First, I'll come to that. These are the judgments which are referred to, which the learned single judge has taken note of. First, my lord will kindly take this, our High Court judgment. It's a division bench judgment 2021 3 GLT 33.
So he has been reinstated, he's back.
No, my lord. Pursuant to the judgment, my lord, we have immediately moved the honorable court. The other division bench, my lord, Honorable Justice Sanjay Mehdi could not take up the matter. That's how this time gave. Otherwise, we file on the very next day. Na? No, my lord, supposing we feel, my lord, it's a case where lordship should consider our prayer at least. Otherwise, my lord, if stay is denied and eventually the appeal is allowed, the situation will be totally different. And on the contrary, if stay is granted and eventually the appeal is dismissed, then also his rights can be taken care of. Anyway, let me place those judgments, my lord. Please come to para 29. Though the facts of the case in Purushottam is slightly different from the facts of this case, there is certain similarity in as much as there has been usurpation of the vacant post by void appointment of an ineligible person, which on the basis of the marks secured in the selection process should have been filled up by so and so. The facts in the present case clearly shows that it was due to the fault of the respondent that Sri so and so had been allowed to participate in the selection process. We are thus of the opinion that right of MS so and so to be selected for the post has been illegally taken away by way of a void appointment, and as such the right of MS so and so under Article 14 and 16 of the Constitution has been violated. Now this is important. We are also of the view that if appointment made is of an ineligible candidate, an appointment being illegal in void was rightly terminated without any need of a departmental proceeding. So this is what the learned single judge has held, my lord. My lord, there is a difference. When a punitive action is taken, then a departmental proceeding is a sine qua non. But if the issue is whether the appointment is accordance with the rules or not, then my lord, perhaps that oral hearing concept which is embodied in 311 will not apply. So it's a clear authority on the proposition which learned single judge has taken note of. Then the other case.
Mr. Chaudhary, have you filed your counter and all?
Yes.
In the retable, my lord. In the retable, no, my lord. This is the.
There's no need of that.
There is no need of.
There is no need of that, my lord. If I am permitted to submit, my lord, I have to, my lord, correct the facts. The show cause notice was issued on 3rd of April that your lordship finds at page 69. Immediately.
No, I think my learned friend can come in, my lord. Let me place my judgments.
No, I'm taking that on.
That's right, the facts, so far as regarding facts are concerned.
There is no problem.
Then we'll hear it finally next week.
Yes. And till then, status quo is on today be maintained, my lord.
My lord, before that, my lord, if your lordship is, my lord, passing any interim order, I may be heard, my lord.
We are not passing any interim order, we are simply fixing a date for final hearing. And we'll hear this matter finally.
No, my lord will kindly allow me to place 2 Supreme Court judgments. Thereafter, lordship will take a call.
Finally, sir.
No, what I'm saying is I'm praying for a stay because
the interim, whatever the arguments in respect of interim order are the final arguments. We'll consider it.
No, only thing is, my lord, tomorrow they might come up with a contempt petition or something. That's why I'm saying it.
Within a week, we are here.
Within a week, we'll get the answer.
Issue notice, Mr. Chaudhary, accept notice on MK Chaudhary, accept notice on
MK Chaudhary senior.
Senior concept. Mr. So and so, accept notice on behalf of the respondent. N. Kumar Sharma. Sole respondent.
Page 2.
Respondent number one is P. Bharat. Services. Issue notice, Mr. So put in appearance on behalf of the respondent number 1 and Mr. Sharma put in appearance on behalf of the respondent number 2. Service is therefore complete. List this matter. Yes, Tuesday. This matter on 9th of April.
I would have been, my lord, 9th of April, Supreme Court, that CA matters are fixed. So lordship will kindly have it on 18th or 22nd, my lord.
Hearing 18th.
Yes.
18th of
Reopening day.
18th of April.
Otherwise, 9th I would have been there, my lord. I'll have to be there.
Mr. Chaudhary, don't go for this contempt and all. We are hearing the finally.
Yes, sir.
Right.
Deeply obliged.
Most of the.
Daily list, item 40.
Please, your lordship.
Mid-season, Your Lordship, in this case, I'm appearing for respondent number 9 and 10. I filed an affidavit today, Your Lordship.
There's
May-
item number
40, Your Lordship.
40,
Let it come up on record.
4 and 5,
9 and 10, Your Lordship.
9 and 10.
I filed an additional affidavit today itself in the morning, Your Lordship.
So what happened to this project?
Your Lordship, the project has not been started because there's a direction from this court not to start that project.
No.
We are the beneficiary.
Still you are in the process of this, still you are interested in doing that?
Yes, Your Lordship, will satisfy that this PIL is not maintainable, in fact.
9 and 10, who are the 9 and 10?
Your Lordship, the person who has been awarded with the contract works for.
Contract.
Yes, sir.
The contract was awarded way back in the year,
2019, Your Lordship.
that still that contract is subsisting.
Yes, Your Lordship.
Lordship, they have filed affidavit today, my lord.
इसमें शायद मुझे कॉन्फ्लिक्ट है एम्फीथिएटर बना रहा है some commercial complex also in as a part of
One
way-
commercial complex market and a water park, Your Lordship.
Water park.
Yes, sir.
तो इसके लिए नेचुरल सेटअप है
Hello, I have filed affidavit in reply today, man. Let it come on record. That's one of five file affidavit in opposition And reply to that, I have filed reply. affidavit. 22nd. Copy. आगे मेरे को सभी के पास है।
The selection took place in which year?
Selection place took place in
2013, my lord.
17.
10 years have passed.
Even then, my lord, I have challenged the very legality or otherwise of the, my lord, selection process.
Now, compassionate appointment, 10 years have passed. What remedy?
This is what, Gaubura.
Gavra.
He has already been appointed.
Already
That's number 5.
Yes. Yeah, from my question. 13.
Mr. Counsel. Yeah. Then 10 years have passed, even though
That's
otherwise
right, my
also, we are not inclined.
Even then, my lord, our whole contention is that, my lord, writ petitioner, my lord, private respondent number 5 didn't appear in and contest the writ petition. And the government has filed affidavit, my lord. That too, my lord, court said there were some serious irregularities in the selection process. However, we are not going to interfere with it. Once court has come to the conclusion that there is some irregularities, therefore it should have been examined, my lord.
The learned single judge has said,
Never said, my lord.
Yes, yes.
both of them have got
Yes,
the
yes.
similar marks, but the sub-divisional officer has
no.
given him more marks. That's why only.
Yes, yes.
Even then, lordship kindly give,
107, para 16.
lordship kindly give me an opportunity so that on the additional stage, my lord, matter may be heard and.
Only, my lord, only a sentence. The appellate order passed by the appellate authority was a cryptic one, which should have been a written one.
This
Only
is
that.
sufficient.
And it is also,
That
taken
the
into
116
consideration, my
is
lord.
already observed, yes, the order is cryptic one, but looking to the other facts and
Yes, yes.
circumstances.
Other facts, my
we
lord,
are not inclined.
only the time. Because in the meantime, my lord, considerable period lapsed. Therefore, we are not inclined to interfere.
Well, that's right.
Even then, my lord, lordship may be kind enough, give me an opportunity, at least for the satisfaction of my client, my lord, on next day.
What about next day?
On 22, my lord.
Yeah.
I'm not taking so much time, my lord, 22.
No, nothing. Please. We'll finish it off today.
Today, my lord, I'm not prepared. On the other hand,
But
copy
there is
was-
nothing to prepare, sir. Prepare in some other case. This is not a case of work. Preparing.
even then, my lord, I have not even looked, my lord, didn't look into it.
There is no need, sir.
I'm sorry, my lord. I thought, my lord, lordship will be kind enough to
Sir, you
accommodate me.
preserve your energy for some other case, better case.
Even then, my lord, is my humble prayer, my lord. Kindly accommodate me for the day, and on 22nd, lordship maybe
Pass over for the day.
Passover, my lord.
Pass over for the day.
No. Let it come, my lord, after view already, I will prepare
Pass
the case.
over for the day, whenever it will come, we'll decide it.
Tomorrow, my lord, day after tomorrow, it will again, once again come.
Again, then we'll decide it on day after tomorrow. What's the problem?
Even then, my lord, I'm not
And,
taking, my lord, long
our
agenda.
request
Only
is don't bother yourself to come for this case only.
it may be difficult. My lord,
There are more better cases, you please do those cases. This is my kuch nahi hai.
then lordship kindly, then 2 more days, my lord, at least on,
Mr. Gonzal,
at least on, my
we'll
lord,
argue on the next time.
8.
The senior counsel will not come. We'll argue on the next. Okay?
I don't know, lordship kindly fix the matter on 8.
We have already done a deal with your junior. He'll argue the matter.
I understand, my lord, but it's a bad case, my lord, absolutely bad case. Even then, my lord, for the satisfaction of the client, my lord, let me have an opportunity.
We'll write that you have vehemently submitted all these things. We'll mention this.
Okay. Item 42.
I was pushing. This is an appeal by the state. Issue is where the Anganwadi workers who were.
The point of limitation is there, Milord. Point of limitation?
Yes, Milord.
I think so. We have already condoned the
The read petition disposed of in 2026-22, appeal was filed on 4/10/23 without condonation application, Milord.
The condonation application.
No, Milord, there was no condonation delay. The Lordship has kindly look into order dated 4/3/2024.
4/3/2024.
Of this court.
In fact,
Milord.
review petition.
Of this court.
But the officer stated is within limitation.
No, Milord. How, no, that's not difficult, Milord. How the office arrived at that this is within the limitation, I don't know. Milord, there is no condonation petition, Milord, to that.
In fact, a review was filed against the judgment passed by the honorable single judge.
Review was filed, that doesn't mean that your
And the-
time will run from that.
Even though if the review is filed, then also you have to move an
Move an
application.
application.
We'll file an application. This will give us just 1 week's time. It will file.
Yeah. Then counsel for the respondent has raised the preliminary objection that this writ appeal is time barred. Would stop, then it counsel for the appellant raise some time to move appropriate application for condoning the delay in filing the filing the appeal. Time period for is granted just after 2 weeks.
Madam.
Item 44.
Not, by an order is it 10/1/23 law?
In the present appeal, the substantial question of has already been framed on 10/1/2024. Hence, admit no need to issue notice as party.
It has already been admitted. 10/1 may admit.
Already admitted law.
It's already admitted.
Lot.
It is noticed that the present appeal is already admitted on 10/1/2024. Hence, list this appeal for hearing in due course.
Deep regulation.
Item 45.
My pleasure also. My lord, here. Clause 10 of the, my lord, tender notice provides that if the highest bidder is deficient in respect of the documents, except court fee and the earnest money, in that case, my lord, 3 days time will be given to him to submit those documents, my lord. That is the clause, my lord. Otherwise, it's a single bid system, so therefore no, my lord, clause, my lord, entails that deficiency in documents would, my lord, render the, my lord, tender defective. Now here in this case, my lord, the first bidder was, my lord, one Ataur Rahman. Though he was highest, he did not accept, rather he withdrew from the, my lord, tender process. So the private respondent, who was the writ petitioner before the honorable single judge, he became the highest. So he was given 3 days time because he was deficient in respect of certain documents. He was given 3 days time to submit those documents and also deposit the, my lord, amount within that time, my lord. Now, in spite of, my lord, elapse of more than 7 days, he did not, my lord, respond to that notice. So therefore, the Panchayat in its meeting, my lord, decided to, my lord, offer the, my lord, tender to the next higher bidder, that is the, my lord, present appellant, my lord. And accordingly, my lord, he too had, my lord, deficient in respect of certain, my lord, documents. He was also given 3 days time. Accordingly, my lord, the deficient documents were supplied and the amount, earnest money, etc., everything has been deposited. The market was settled with the, my lord, present, my lord, appellant, and accordingly he had been running.
Now, my lord, after more than a month, my lord, the private respondent, my lord, as a writ petitioner, my lord, approached this court, saying that he did not receive that particular notice by which he was, my lord, asked to deposit, submit the documents within a period of 3 days, my lord. So therefore, my lord, on receipt of that, he within the time approached the, my lord, Panchayat, and Panchayat did not, my lord, look into all these things, and the my lord, the market was settled with the, my lord, this present appellant. Now, Honorable Single Judge, my lord, while, my lord, scrutinizing the rival claims of the, my lord, parties, has come to an opinion that the present appellant, in respect of the present appellant, certain documents were not enclosed. So therefore, the tender of the, my lord, present appellant was defective.
Where is that?
My lord, will find, my lord, is at page 39, relevant of the, my lord, 44,
11th para.
paragraph 13, my lord, page 44.
13.
Lordship, page 44, para 13. BW exponent number 5 was not complete, my lord. It is no one's case, my lord. It was not the case of the writ petitioner as well, my lord. Nor the tender condition provides so.
তো আমি দেখছি
For expression man, he said, yeah. If you do restore his he knows his wife for me. Thinking he did not respond. बाद में आके फाइल किया कह रहा है कि मैं दिखाता हूँ मैं रिस्पॉन्ड करने लगते तो कौन चला रहा है दिसंबर का ऑर्डर
Who is running the fishery now?
Now, my lord, the respondent number 1, private respondent.
Is
Pursuant to the judgment, my lord, he has taken over the charge, my lord, so he's running. Honorable Single Judge has also failed to take into note that the representation he has submitted, it was after the decision of the, my lord, the Panchayat to, my lord, grant this settlement to the, my lord, present, my lord, appellant. And accordingly, my lord, the order of settlement was already passed, my lord.
No, this representation, he moved representation on 15/7/2000.
15/7.
And your settlement was done on?
My lord, I was given notice on 14/7, my lord, 2023. Board sat on 14/7/2023 because notice was issued to him on 6/7. So the 7 days time has expired on 13th. So board sat on 14th, and I was intimated to submit my documents within a period of 3 days. And I have deposited, my lord, the same, my lord, on 19, my lord. Thereafter, my lord, on 15/7/2023, he submitted the representation. 14th decision was already taken. So, my lord, the decision, my lord, of the Panchayat could not have reflected the representation.
Finding recorded by the single judge that your bid was not complete.
Lordship, my lord.
In many respects.
Lordship, my lord. From the tender, various tender clause, your lordship will find the submission of the documents, my lord. One has to submit, but in respect of port fee and the earnest money, if my lord, the person tendered, my lord, if he comes out to be the highest tenderer, in that case, my lord, except the court fee and the earnest money, rest of the documents, he will be given 3 days time. So even if I have not submitted certain document in respect of the tender, moment I became the highest tenderer, so I'll be entitled to 3 days time. Accordingly, they had given me 3 days time. The deficiency which I had to meet is the same, the deficiency the writ petitioner had suffered. my lord.
टेंडर खुलने के बाद किसी कारण देखा जाता है जब तो 3 दिन टाइम दिया ठीक है ये टेंडर इंक्वायरी कब से मई 2025 ठीक है फर्स्ट सेकंड yes, then they decided to pick that's when the date of the tender to live. That's what I did at someone I had it. That's जब तक आगे बढ़ते गया तब मेरा नंबर जब आया तब से मुझे फील नहीं लगा ये एफिशिएंसी तो लगी तो पहले तो ये करना नहीं पड़ता विजन फॉर अभी डॉक्टर ने मतलब अभी
This tender condition does not say, my lord, if tenderer, my lord, fails to submit any document or they are lacking certain documents, in that case, his tender will be rejected as such. The clause 10 makes it, my lord, very clear, only in respect of, my lord, those two.
ये तो एडमिट हो चुका है आगे खत्म कर सकते स्टे वाज नॉट पॉजिटिव
Yes.
Private respondent, my lord,
respondent number 1 is the private respondent.
his notice was deemed to have been accepted. We have taken dusty service. He did not appear. My lord, affidavit we have filed that was accepted as deemed service.
It has been listed for admission.
On the last occasion.
Admission के लिए तो listed है.
Why it is listed for admission? It is already admitted.
It's not, perhaps not admitted, my lord.
Admitted on 21st of January 2024. PJ Sekia, AM Khan, non-concept appellant, admit. In the meantime, parties are directed to Mr. Status quo as on today. The matter is already admitted.
Admitted, my lord. I'm sorry, my lord, I did not notice. My lord. But otherwise, also the private respondent who is the most affected person, my lord, he is, my lord, though notice has been served, has not appeared before your lordship, my lord.
Okay, the matter is already admitted. This for a final hearing on this 9th of April.
Oblige.
Supplementary list item 47.
Lordship, the matter relates to the payment of disability pension. We have given him the respondent disability pension from 2005.
But he moved the petition or original application before the tribunal in 2020, Lordship, claiming that it should be rounded out at 50%. We gave him 30%. So, so far as 50% round of concern, Lordship, we may not have major grievances. The major grievance that the tribunal has ordered that to give him 50% from as an area from 2005. Only that part we are challenging, Lordship. While we relying on Supreme Court
You are
judgment,
not
Lordship.
agreed by this 50% round off.
No, that part is not, but from the area from 2005. So Lordship, I'll be relying on Supreme Court judgment. He said that only from the 3 years prior to the filing of the petition only. And similar case, Lordship, Calcutta High Court and Calcutta High Court and Jammu and Kashmir High Court has admitted, Lordship, and stayed, Lordship.
Yes.
I'll be relying on paragraph Lordship 5 and 6. Last two sentences from paragraph 5, Lordship. Of the judgment, Lordship, I am relying, Lordship. Paragraph 5, last two sentences, Lordship. Insofar as the consequential relief of recovery of arrears for a past period, the principle of relating to recurring successive wrong will apply. As a consequence, High Court will restrict the consequential relating to the arrears normally for a period of 3 years prior to the date of filing of the writ petition. In this case, the delay of 16 years would affect the consequential claim of arrear. The High Court was not justified in directing payment of arrears relating to 16 years, and that too with interest. In this case, also interest was Lordship imposed, Lordship. It ought to have been restricted to relief relating to arrears to only 3 years before the date of filing of the writ petition. So Lordship may issue notice at this stage and Lordship may stay that part, Lordship. Arrear part, Lordship.
Arrear beyond 3 years.
Beyond 3 years. Lordship.
Notice to respondent returnable on so and so. Requisite to be filed within a period of 1 week and filing of the same letter. Notice be issued to the sole respondent returnable on so and so. In the meanwhile, the impugned direction of payment of arrears to the respondent with effect from 1/1/2006 shall remain stayed. However, the arrears to the respondent shall be paid from 3 years prior to the filing of OA number 15/2020 before the Armed Forces Tribunal Regional Bench, Guwahati.
Deeply obliged, Lordship.